first task that I face today is for a determination which I did not make at the end of the evidence, and that is for a determination as to whether or not the crime for which I found Mr. Loganbill guilty was sexually motivated. Once I make that finding, we will then go to the sentencing phase, which is the second phase for today. I am going to divide those up. And so, counsel, I'm going to ask each of you to first address that issue of whether or not I, as finder of fact in this case, should determine that the crime was in fact sexually motivated. Ms. Eaton, please proceed.
Did you want me to address you from the podium, or
I do. I want you to address from the podium. And I know that, and I'm sure I should have mentioned this at the outset, I note that there are quite a few people on Zoom today. I'm going to ask that everybody do exactly what they're doing now, and that is to keep their microphones muted at all time during the proceedings. I'm also going to ask, as I believe everyone is now doing, to keep their videos muted. And when I get so many people on the screen and the video is activated, that tends to be kind of distracting to me. And what I'm going to attempt to do is during the Zoom hearing, put the camera on the podium when people are speaking okay, it's not reflected up on the big screen now, but I do believe now the Zoom is focused, the Zoom hearing is now focused on the podium. Ms. Eaton, please proceed.
Your Honor, the state is asking that you make the finding that this crime was sexually motivated today pursuant to the Kansas Offender Registration Statute. That statute is KSA 224902. As the court is aware, in that statute, there are several sexually, not even just sexually motivated, but sex crimes that fall under the statute that are listed as sexually violent. But at the end of the statute, in subsection C18, there is kind of a catch-all that says that the court may find beyond a reasonable doubt that a crime is sexually motivated. And that doesn't have to be a crime that's already been laid out in the rest of the statute. And in my sentencing memo, I point the court to State v. Gallardo, which is Gallardo, and that's 43 Can App 2nd 346. In that case, you had a situation where a defendant was charged with lawful sexual contact, except that he was a guard at one of the detention facilities and basically had an inmate who was performing sex acts on him. And so that was not a crime that fell within those enumerated crimes in the statute. However, the court in that case said that obviously based on the acts that occurred, it was sexually motivated. And within that case, they said that this can encompass any crime so long as its prime motivation is sexual gratification. And so I think in this case, the court is aware of what the evidence was, so I'm not going to go do a deep dive into that. But you have a situation where the defendant has started taking these pictures and videos of the victim in this case almost immediately after meeting her in August of 2019. And that behavior continued until March of 2020, when the students left for spring break and didn't come back. The court has heard the nature of those photos taken, that they were all exclusively, almost all exclusively focused in on the victim's buttocks. And there were some videos of her whole body, but for the most part, they were focused in on that. Additionally, you heard that the defendant himself said that he found her attractive and that is why he took those photos. And again, to directly quote him, and if you'll give me just one moment. When asked by investigators if he looked at the pictures of AA at home, he admitted he did. And when asked if he was looking at the pictures because he was sexually aroused by them, he said, "I have, yes." He said it's fair to say that he finds her sexually attractive when he is looking at pictures of her. When asked specifically if he found the images that he took of AA sexually attractive, I would not have done it otherwise. And so I don't think that there is any more clear evidence than the fact his own words say that it was sexually motivated. But as I told the court when we heard this case back in September, I think that you have to look at the context of the other evidence that was introduced in this case, and that was the Google searches. And those were obviously, we heard about some searches regarding where AA danced and things where her dance competitions were, but then you also heard about the nature of his searches for pornography. And obviously, I'm not arguing to the court that looking at pornography is illegal. Some of it is when it involves children. But the nature of his searches was teacher-student, students in tights, things of that nature. And so I think when you look at that conduct with his statements about what he liked about Adeline in this case, it points us in the direction that this is very clearly and was very clearly sexually motivated. And so I think when you look at that context, additionally, I will advise the court, and again, this is in my sentencing memo, but we did not introduce this evidence at trial for other reasons, but I think it's pertinent to today. What we found for Mr. Loganbill, and once we, he was interviewed and then the devices were searched, is that the victim in this case, this was not the first time that he had done this. There were other students in other years that he had done this, he admitted to, and there are pictures on those devices of them. And so basically he admitted to the investigators that he, picks a girl every year. And he's really driven crazy by the girls when they wear black tight pants or gray tight pants, the leggings.
And I hesitate to do this, but just for the record, I don't remember ever seeing the word crazy.
I don't know that that was a direct quote. He said that he very much.
Objection sustained. Go ahead.
His statement to investigators was that he particularly liked the girls in the tight leggings. And so again, I think when looking at that in the context of what happened in this case, it's very clear to see that this was sexually motivated. And the court, obviously pursuant to statute and case law, can make that finding.
All right, thank you. If I'm not mistaken, the current statute applicable would require a registration for 15 years.
That is correct.
All right. Mr. Cornwell.
Thank you very much, Judge. Let's just suppose that Mr. Loganbill did some research on this. Because when you come into a court of law or when you are charged with a crime, as a citizen of this great country, you are deemed to know the laws under which you live. So he thinks, this is hypothetical, because he did not do that. But the statute says there's a list. Rape, sodomy, aggravated sodomy, child molestation. It goes on and on and on. But there isn't an enumeration. There isn't a sentence for stalking. Well, the prosecutor can say, and the legislature can say, well, he needs to read the entire statute. And so when you read the entire statute, any act, this is 18 of the cited statute, any act which has been determined beyond a reasonable doubt to have been sexually motivated, and then it goes into the Romeo and Juliet
A fairly specific exception that doesn't apply here.
Specifically motivated means that one of the purposes for which the defendant committed the crime was for the purpose of the defendant's sexual gratification. So if he was doing some research, well, there's rape, I can't be doing that, and all of the enumerated crimes that are there, and then there's this catch-all. She talks about Gallardo. I don't think there's any question Gallardo is a sexual predator. That's the least of his sins. But to say that stalking falls within that, when the legislator didn't enumerate it, but we've got the Court of Appeals saying what they said, We are convinced that any reasonable scrutiny of the entire legislative scheme was for this statute, or that this statute manifests a strong legislative intent to broadly include within the statutory ambit virtually any crime committed with sexual gratification as its motivation. So I guess what he should have done then, after he does his research, gets confused by subsection 18, well, I better go look at the law. I would better see what Gallardo says. Because I don't want to do anything worldly wrong that is a crime. Because he didn't. And I understand that's going up on appeal. Did he commit a moral crime? Absolutely. Did he do any other number of things that don't amount to a crime? Yes. Some are way above a misdemeanor stalking. That he lives with. That he's going to have to come to grips with. So I don't believe, Judge, here, based upon what we have, that we have a sexual motivation. Now, Gallardo says what Gallardo says. I'm hoping that we're going to be able to reverse that on remand. And one more thing, the new statute amends it. Well, if that had been in there, then it wouldn't have been a stalking charge, and it wouldn't have been a sexual motivated charge. So what we've got here is the legislature, the district attorney's office, coming up to try to plug this hole. It's not about whether or not he did it, Judge. We all know that he did it, but it's under the statute, we do not believe it's sexually motivated. Thank you.
Ms. Eaton, I'll give you a short response if you wish.
I think that will be very short, but I think that both the language in the statute and then the language in the case law is very, very explicit and is or any crime. And the cases that have prosecuted, including where a person would break into a house and steal women's bras and panties and then go home and do whatever he did with them. And that finding was made in a theft or burglary case because there are any number sometimes of reasons that these crimes are committed. And so it is applicable in this case too. While it is not something that maybe this court has seen every day applied to a stalking statute, it certainly fits under the letter of the law and the case law.
All right, thank you. All right, I appreciate comments of counsel. Our legislature has chosen to define as a sexually motivated crime one that was committed for the purpose of defendant's sexual gratification. As I will discuss in a moment, this finding has little to no effect on the length of the sentence to be imposed. Instead, such finding would enhance the penalty for such crime by requiring registration as a sex offender for a period of time specified by the statute. Current statute specifies that time at 15 years. As to this finding, I believe the determination is frankly quite obvious. Making findings in cases that require specific intent can sometimes be quite difficult, many times trying to determine specifically what was someone's intent from their actions and not being able to literally read their minds. Although here, I do not believe it is much of a stretch from the evidence admitted of perhaps hundreds of pictures and or videos of the victim's buttocks. However, I believe that much more compelling evidence is frankly the admission of Mr. Logan himself, the one he made to the detective, that he was sexually attracted to this young girl, and that is why he took the pictures and the videos and was why he was attracted to her. Frankly, this, along with the rather troubling evidence of the types of images Mr. Loganbill was searching on the internet, make it a rather simple task to find beyond a reasonable doubt, and I do find beyond a reasonable doubt, that the crime was sexually motivated. I would note that the statute at issue, KSA 22, 4902 and 4906, as Mr. Cornwell correctly points out, do not specifically reference this crime. However, both of those statutes make reference to any act which has been determined beyond a reasonable doubt to have been sexually motivated. And further, as noted by the state in its sentencing brief, it appears the Court of Appeals has determined that these statutes apply to any crime motivated by a desire for sexual gratification. So as a result, I do find beyond a reasonable doubt the commission of this crime by Mr. Loganbill was sexually motivated, and thus, Mr. Loganbill, you will be required to register as a sex offender per the applicable statute for a period of 15 years. Your responsibility to comply with those registration statutes will be yours. It'll be your responsibility to familiarize yourself with those statutes and the terms and conditions. Your failure to comply with any of those terms and conditions can result in criminal prosecution. And Mr. Cornwell, at the end of the proceedings, I'll have Brenda hand you the necessary paperwork that you'll have to complete. And now, as we proceed to the second phase, just one more comment I'd like to make. Obviously, there are going to be some folks here today that are going to be given the opportunity to speak on behalf of the state and or the victim in this case. It is likely that some of those statements may be statements to which Mr. Loganbill and or folks here in support of him may take issue with. But that is their right to make those statements, and I'm going to trust that you folks will remain, as I would say, poker-faced while those statements are being made. I will not permit guffaws or outbursts in the court, as you may hear some things that you may or may not find offensive. If you don't think that you can hear such things and remain poker-faced, then you may need to remain outside the courtroom. By the same token, Mr. Loganbill obviously has a constitutional right to make a statement today, as there will be a right for some folks there on his behalf to make statements. One or more of those statements may be found offensive by some folks on the other side of the room. The same rules apply. He has that right. And if you don't think you can sit through statements like that and remain poker-faced, then perhaps it would be best for you to remain outside the courtroom. All right. Now, as we move to the sentencing phase, Ms. Eaton, are you going to be making your comments at the beginning or the end?
I would prefer to reserve my comments for after everyone has spoken.
All right. How many folks do we have here to speak today?
We have 4. We have the victim and then her mother and then 2 other parents.
All right. I will let you have them approach the podium in whatever order in which you call them. I think he has a microphone hooked up already. Is that what you're talking about, Cindy?
There is a. Do you want me to? Not sure I can.
Oh, probably not. All right, Ms. Eaton, I would ask that you introduce each person as they come up to the microphone.
Sure. This is Adeline Antonucci, and I'm going to let her spell her name for you, Cindy.
Fair enough. Go ahead.
Adelyn. The last name Antonucci.
All right. Thank you. Go ahead.
Hello. I would like to thank everyone who has supported me through this situation. I want to thank my family, my parents, the detective, Judge Sutherland, and my classmates and community. A year and a half ago, I was a 10-year-old child who enjoyed school, dance, being involved in 4th grade activities. I never thought that a situation like this would ever happen to a kid like me. I started 4th grade like most other kids and came out of 4th grade with my innocence taken. I had to have conversations about grown-up things that I was not ready to have. I felt scared, embarrassed, humiliated, and fearful of adults. I left 4th grade scared of men and even scared of kids my own age who would walk behind me in class. I now always look over my shoulder and can't sleep at night out of fear. I questioned why someone I had seen as a role model and trusted as my teacher would do this. The feeling I had standing on the playground at recess and hearing my friends say, "You, Mr. Loganbill, had been taking photos of me." I felt like the smallest person. That is a feeling forget. A child should never be made to feel like this by an adult, and especially not by their teacher. Kids deserve to be kept safe. Kids are meant not to be preyed on. You had a job to protect your students, but instead you used us. I know my worth is so much more than how you saw me. I am still working on overcoming my fears and scars you left behind. But I can promise you, I will grow to use the situation to help other kids who go through something like I did. I will take this situation as fuel to become the strong, powerful girl I am meant to be. This situation will not define who I am. In elementary school, we are taught that actions have consequences. I ask that if you are truly sorry for your actions, that you will accept your consequence and let all victims move on with our lives. Today, I'm not only standing up for myself, but for Paige, Megan, Deja, Rachel, and every other student you have victimized for the past 31 years. Today, I'm the voice for all of those that you have hurt. I was not the first child victim of James Loganbill, but hope to be the last. I'm asking that you please make sure justice is served, so no other children have to lose their innocence. How much is the safety and innocence of a child worth? Thank you.
Thank you. Ms. Eden?
The state would next have Kyle Johnson.
Mr. Johnson, could I trouble you to first state your full name and go ahead and spell your last name?
Sorry, excuse me. Yes, Kyle Johnson, Johnson.
Very much, sir. Go ahead.
Thanks. I'm going to be brief. There's probably not a lot I can add to that. Adeline is an amazing little girl. My daughter was in class with Jim Loganbill's 2019 fourth grade class along with Adeline, and she and her friends noticed and ultimately reported Mr. Loganbill's behavior. Since then, it's had a dramatic impact on her. She's had to deal with so many feelings and things that she wasn't ready to deal with yet. She felt guilty for causing her teacher, who she really liked, to lose his job. She was sad that her teacher, who she liked, was gone. She was upset with how kids in school felt about her. The hurt extends to how she relates to adults today. It extends to how she views men today. That incident is still with her, and it's going to be with her the rest of her life. It is a serious thing to have the underpinnings, the foundations that kids expect in the world, to have them ripped out from underneath them like that. Somebody who they expect to trust and rely on. It's a very serious thing to have happen to them. And if I understand correctly, the statute says that Jim can't be punished with any more than a year in jail. That's not nearly enough. Doesn't even come close to being enough. So he doesn't deserve a day less than that. That's for darn sure. He clearly has no remorse. This man's a monster. He knows he's the monster, and he spent the last 30 years making sure that he had access to his victims on a daily basis. This isn't something that's just happened. There is something broken in Jim Loganbill's brain, and if you let him near little kids again, he is a ticking time bomb. We're all very lucky that this isn't a lot worse situation than what it was.
Thank you, sir. Ms. Eden?
Next, the state has Shannon Leeper.
All right, ma'am, if you'll please go ahead and state your full name, spelling your last name.
Shannon Leeper, ShannonLeeper.
Thank you. Go ahead.
Betrayed, confused, sorrowful, gross, angry, regretful, heartbroken, gloomy, insane, stupid, miserable, disappointed, depressed, and naive. These are the words of a 12-year-old that asked me to share that with you today. A child who also wrote how it has been really hard to do everyday things when she gets dragged down by the thought of him. She wrote of her worry that something like that would happen again after returning to school. She wants you all to know how she still cries sometimes just thinking about it. Mr. Loganbill, she wants you to know your actions have changed the person she is and how naive she was to, quote, fall for your tricks. I am here as a voice of a 12-year-old child you have not heard from before today. A child forever changed by the predatory actions of her fourth grade teacher, Mr. Loganbill. My decision to address the court is not an easy one, but it was the only one. The courtroom is a familiar place for me. Talking about sensitive details of abuse and victimization has been a large part of my professional life the past 20 plus years. The bulk of my career has been spent investigating crimes of child abuse and neglect, sexual assault, domestic violence, and stalking. As a special victims detective right here in Johnson County, Kansas. Yet none of that could have prepared me for the call I would receive in March of 2020 as I was wrapping up my workday, looking forward to the next week, spring break. That is when I received a call from a detective in a neighboring jurisdiction. I will never forget how the phone shook in my trembling hand as I learned my child had been identified as a potential victim of child exploitation at the hands of her all-time favorite, most loved teacher, Mr. Loganbill. I was hit with the sickening realization that James Loganbill had manipulated and groomed my 9-year-old child and me throughout her entire 4th grade year. In the days and weeks that followed, I sifted through hundreds of photos and some videos, having to identify those of my little girl, photos of my child, captured in compromising positions, in the one place all children should feel safe and secure, the classroom. I can't adequately describe the level of disgust and anger that consumed me as I had to identify some photos simply by reflecting back to my 9-year-old little girl's favorite shoes and pants, because James Loganbill had a tendency to zoom the camera lens in on the private body parts of little girls. It became quite clear to me that James Loganbill was preferential in his attractions to certain children like my 9-year-old girl. Children often dressed for classroom comfort in tights or leggings that hugged their small prepubescent bodies. The photos told the story of a predator manipulating children into sitting in certain places in certain ways with the hope of capturing images for his personal sexual gratification. I was hit hard with the sickening truth that James Loganbill had been quite skilled in masking his admitted attraction to my 9-year-old child by providing constant praise and positive feedback throughout an entire school year. In the months that followed, I learned that James Loganbill had been previously accused of inappropriate behavior directed at multiple young female students while teaching at an Olathe middle school. From my training and experience specific to child predators, I knew James Loganbill had likely preyed on young girls throughout his 30-plus teaching career, but that didn't lessen the blow after discovering the disclosures of multiple students had been largely ignored. With the quiet transfer of James Loganbill to an Olathe elementary school, it is hard to comprehend how highly educated, mandated reporters and school administrators could so recklessly move a known threat to the safety and security of our children to another school within that very same district, affording access to even younger and more vulnerable children without so much as a warning. Those who had direct knowledge of the accusations against James Loganbill many years ago bear some level of responsibility for the continued victimization of other children, including my own, and you all should be ashamed. James Loganbill was left unchecked in the classroom with a school-issued iPad he casually used as a camera to prey on his unsuspecting students. And to suggest today that his conduct has not left lasting and harmful effects because they learned of his predatory stalking behavior after the fact would be ignorant. I am thankful this court recognizes that all victims who discover they have been the target of stalking after the fact should be heard and their perpetrators held accountable. To suggest James Loganbill's actions were not sexually motivated is quite frankly laughable, That is, if we could find any humor at all in this horribly disturbing investigation. Should we take comfort that the child victims in this case were fully clothed when James Loganbill preyed on them, while admitting having an attraction to prepubescent little girls, including my own? Would it be responsible of us to theorize James Loganbill poses no threat to the safety of other children because he admitted his behavior was both creepy and morally wrong? In my experience, past is the best predictor of future, especially with a known course of conduct preying on young girls. My background has been both a blessing and a curse. As I have tried to navigate through this experience through two very distinct perspectives. One, as a trained subject matter with regards to victimization and child abuse and sexual assault. And two, as the mom of a little girl, determined to ensure her safety and emotional well-being. Professionally speaking, I know children are most often preyed upon by those closest to them, trusted adults. As such, young children rarely understand and recognize the subtle grooming techniques used against them in those moments of victimization. With the passage of time, however, and often through the help of therapy, more details come to the surface, along with some very painful realizations. In fact, just 2 weeks ago, my child came to me with a heaviness after processing some really tough stuff. She told me how gross she felt, knowing it was no accident or inadvertent touching when Mr. Loganbill would greet her with a hug and run his hand down her back to her buttocks, while dishing out fist bumps and high fives to her male classmates. Her last memories of her elementary school experience are sadly those of victimization at the hands of James Loganbill. And as she and her classmates went off to spring break that rolled directly into a pandemic lockdown, Mr. Loganbill quietly left the school without an explanation. Instead of termination, he was graciously allowed to retire and enjoy the benefits of a full pension. Meanwhile, multiple families were left trying to sort through it all and put the shattered pieces back together. I have quietly stood back to allow this investigation to take its course, trusting in the criminal justice process. I, along with many of you, watched as this court rightly handed down a verdict of guilty on September 8th of 2021. It is no coincidence I selected that date as my last of a 23-year career in law enforcement, needing to see this case come to a close before closing that door. Today, I pray this court hands down the most appropriate punishment, one in line with the tremendous harm and lasting effects caused by the predatory and abusive behavior of James Loganbill. A jail sentence of 12 months and registration as a sexual offender for 15 years are both reasonable and my request. Mr. Loganbill, you inflicted immeasurable harm upon my bright, beautiful, confident, trusting 9-year-old little girl. Her happiness and excitement in the classroom were replaced with fear and sadness, and you did that. As a result, I now find myself looking for signs of resiliency in my own daughter. skilled children are not born with, a survival skill born out of trauma. And you, James Loganbill, did that. I stand here so very proud of my daughter, her bravery and her determination as she works daily to put this nightmare behind her. And as we all move forward today, please be mindful of your words as you talk about the circumstances and the children involved in this. Please understand how painful and difficult this has been. Please respect our privacy. And finally, as I close, I will leave you with this. We all have a duty to protect all children, even those who are not our own. If a child makes a disclosure of abuse, believe them. If a child reports concerning behavior, look into it immediately. And if you even suspect abuse or neglect has occurred, please report it. Be the good. Our children are counting on us. Thank you.
Thank you, Ms. Eaton.
Your Honor, the state has Kristen Antonucci next.
As with the ones before you, if you'd please state your full name and spell your last name.
Kristen Antonucci, Kristyn, last name Antonucci.
Thank you, ma'am.
Thank you. Hello. I would like to start off by saying thank you to Judge Sutherland, the District Attorney's Office, and Detective William King, and the community of supporters of our family in the Not Your Daughter movement. We are beyond grateful for the outpouring of love we have received the past year and a half. Our lives forever changed on March 11, 2020, when we learned that our worst nightmare had come true. Never did we think a situation like this would happen to our child and our community. I had so many sleepless nights wondering what I would say on sentencing day. What would I say to the teacher we trusted to care and protect our child? What would I say to the grown man who used my innocent 10-year-old's body for his own sick gratification? Most of the things I'd like to say are really not appropriate for court. After first learning about the actions of James Loganbill, we went through a fury of emotions. Pure confusion, overwhelming fear, intense anger, sadness mixed with more fear. What signs had I missed as a parent, and how could I not know? What I didn't realize on the day that we found out that James Loganbill had been stalking our child was that I had missed the signs, because this man was really good at manipulating and concealing how he'd been using his classroom for his fetishes for over 30 years. We worked to console, comfort, and reassure our 10-year-old daughter that she had done nothing wrong. She was so confused, frightened, humiliated, and did not want the teacher she knew as a role model to get in trouble. She felt horrible for his family. She felt horrible for his children. She did not want to believe that these allegations were true. Before we made our story public, we started receiving phone calls, texts, and emails from people we had never met. People when children in a school are involved in this situation, word traveled fast that Adeline was the girl that James Loganbill had taken a fascination with. People began calling with the most invasive questions about our daughter and her relationship with her teacher. Kids from our school began talking on Fortnite Messenger and social media about this girl, Adeline Antonucci, who was 10 years old, and James Loganbill, saying untrue and awful things. At the end of the year student council meeting that was held by Zoom, children began to talk about her in this situation, where she was able to read every single word they said. The game of telephone was in full effect, and our family and our daughter were the target. It was after we began hearing untrue accusations that we decided we wanted to be in control of the story and in control of the situation. We were already dealing with so many emotions, and the waiting game for him to be formally arrested felt like forever. Once we made our side of the story public, our email and phone started ringing off the hook. Students who had had James Loganbill for the past 30 years began to tell us of the grooming behavior they experienced under his watch. Teachers came forward to tell us the behaviors they witnessed and had reported to administration about James Loganbill, where his actions were towards young girls that made them feel uncomfortable. Moms of boys who had Mr. Loganbill messaged us to tell us how their sons had noticed the special treatment he would give young girls in the class. Parents had their daughters transferred out of the classroom in the early 2000s after he made inappropriate comments in reference to his middle name, James Dick Loganbill. Even a few children who were so brave and whistleblowers contacted us, letting us know they told their principal and counselors in the 1990s about the unwelcome attention James Loganbill was showing his favorite female students. A mother who now lives in Texas and is in her late 30s contacted us to discuss the grooming behavior she received as his favorite girl in the 90s, which included inviting her over for dinner, pulling her out of class if she was upset with him, having her eat lunch alone in the classroom while she sat on his lap. She called me in tears, now having a daughter of her own and knowing how she was groomed and used. The fear and that feeling had rushed back to her. The most heart-wrenching stories also came from a group of 10 middle school girls who were 12 when they had James Loganbill. After he groomed them, wrote them love notes, called them his daughter, attended games they would cheer at, requested photos of them in their cheer uniform, and would keep drawer space with their special treats in the back room of class, he would also then rank them using their photos of the girls by who he found most attractive and who was his favorites at the time around his computer monitor. Those girls so bravely went to school officials where an investigation took place and they found that James Loganbill had sexually harassed the multiple young girls and was forced to transfer to my daughter's school. A lengthy investigation had taken place and he received nothing than a mere slap on the wrist at that time. We soon came to realize that our daughter was not alone. In fact, she was just one of the many victims of James Loganbill throughout his tenure. This leads me to today. We want to thank you, Judge Sutherland, for all of your due diligence in this case. We know you cannot change the original stalking law and how it was written, and we respect how you will sentence this case. The stalking a minor law we passed this year flew through the legislative process with a huge bipartisan backing, where votes on both sides of the aisle were unanimous. The governor and legislators agreed that the penalty for this crime were not tough enough. Now this same crime, a felony level with increased jail time. As this man continues to work in the community, we believe it's only fair that he is placed on the registry list so our community is aware. So thank you for that. With that being said, please note that this man had been warned multiple times throughout his 31-year tenure as a teacher that his words, actions, and behaviors towards young female students were inappropriate. These sweet girls and victims dealt with their own shame, their own humiliation, their own embarrassment and confusion. He had the opportunity when he left that middle school in just 8 short years ago that where he had founded to sexually harass those 12-year-old cheerleaders to stop his behavior towards young girls if he were truly sorry. But he did not. Instead, he went on to the elementary school where he continued to not only prey on my daughter, but other 9 and 10-year-old girls. Any humiliation that this man feels is a direct result of his own actions. If he were truly sorry and had repented for these actions, he would stop making children go through further heartache and accept the punishment for his actions. In closing, one thing that comes to mind is when my husband and I attended back to school night in August of 2019. Little did we know that just days later, he would begin stalking our daughter, taking photos of her, preying on her when she was doing simple 4th grade things like playing at recess, walking down the hall, tying her shoe. And this would continue on for 8 months. That night, at back to school night, Loganbill said to the parents in attendance, "People always ask me if in my 30 years as a teacher, if children change. I always tell parents, no, kids haven't changed in the 30 years. Technology and curriculum changed, but not kids." Well, you were wrong. Kids had changed, and the children you had in your classroom in 2019, 2020 were like no others you had had before. They were brave, vigilant, strong, and exposed you for the sick man that you are. We are so grateful for those smart girls who knew something was wrong and did something about it. This man used my daughter's body and looks and made this child into a these victims of James Loganbill, as well as other children who have had their innocence taken at the hands of a predator. This behavior has no place in our community, no place in our schools, and no place in the state of Kansas. I truly do not believe that this man is sorry, but he's sorry that after 31 years of grooming and victimizing young girls, he was finally caught. We ask that this stops here and stops today. Please give this man the punishment that he deserves and the closure that all of his victims need. Thank you so much.
All right, Ms. Eden, your comments now, please.
Your Honor, I laid out in my sentencing memo the relevant statutes that pertain to your sentencing today. But I will just go through what from the state's perspective, our best case scenario is down to what we would ask if you don't follow that. So at this point, based on everything that these people have told you today, it is incumbent upon me to ask for 12 months in jail for Mr. Loganbill. I think Mrs. Antonucci just kind of hit the nail on the head just now. This isn't a case where this is the first time that something like this has happened. It's the first time that it came out. And so it's his first conviction. But he has to continue doing this. And so he should not receive another slap on the wrist. And frankly, the court is aware that we all wish that the penalty was more serious. And that has been changed. We're stuck where the 12-month sentence. And so we would request that. I will tell you that a lot of times in cases like this, we see a situation where perhaps the parties agree or the parties ask for the court to do shock time or jail time up to 60 days. In this case, that's not available because this is a misdemeanor. And when you look at 21-6607 subsection 14, it specifies in felony cases except DUIs that 60 days can be ordered. And specifically, there is case law. I did not end up putting that in my sentencing memo, though I meant to. So I have brought that case for the parties today. And I can pass that out to the court if you would like. But it's State v. Trenton Coleman, Kohlman, and it's 18 Can App 2nd 432. And basically, it's another case that may I approach.
And Mr. Brandenburg.
It is the gist of that case is it's another case where the court says the legislature means what it says. And the fact that the statute for sentencing was written and that subsection 14 says in felony cases except DUI, that it is not applicable, that you cannot order that shock time in misdemeanor cases. And so that is one of the reasons in this situation where we're asking you to give the full 12 months. I couldn't stand up here and argue for it any better than the people that spoke before me. I think that this is a crime that on its nature, people want to act like it isn't serious, like it doesn't impact the people involved. And what we've heard and seen is that it does, it really does. And you've heard from Adeline and the people who love her most about how she has changed. And how her safety and comfort have changed. And certainly from Detective Leeper, who again, we were not able to charge the conduct because it was years ago, but how that's affected her daughter. And you're going to hear that over and over again. I know that the state provided to the court and council other letters from community members, and some of those did include girls or women that were in Mr. Loganbill's class who had been other victims, including some of the ones that Mrs. Antonucci references when she talks about the ones that were in middle school. You've got letters from them. And this is something that they have to live with for the rest of their life. And when you are objectified in that way, it does do trauma to you. But when you think about the fact that these girls were in a place that this person was in a trusting relationship, but also a position of power over them. And then I think back and track, things that is so terrifying about this is that, yes, we can all sit here today and say, thankfully, that no one was touched, that there weren't pictures that were unclothed. But what we know based on his Google search is that he certainly must have been thinking about it, because he definitely Googled news headlines about when teachers committed crimes against their students. And that is concerning. I think it's terrifying. And I think that that goes to the frame of mind and the seriousness of this crime. So we sit here very lucky today that we don't have victims who were touched or pictures taken of them when they were naked. But that doesn't discount the criminality of this or the propensity for this behavior to have gotten worse. And I think that's one of the concerns and one of the things that the court needs to look at in the appropriate sentence for him. And I think that's why a jail sentence is appropriate. If the court does not grant a 12-month jail sentence for him to serve, there are those other statutes, as I pointed out in my memo, do provide for things like house arrest. Obviously, they provide for probation. If the court is not going to impose a full jail sanction, then I would ask the court to consider an amount of house arrest that it deems appropriate. If the court is going to grant probation, our request would be that Mr. Loganbill be ordered to do a sex offender evaluation and follow the treatment of that, that he not be allowed to work around children, that he not have access to internet, and no contact orders with the victims and witnesses in this case. But that would be our request, is 12 months jail.
All right, thank you. All right, Mr. Well, is Mr. Loganbill going to be addressing the court today?
Judge, we've talked about his right to allocution. We've gone over his could or could not. He's indicated to me that he would like for me to speak on his behalf.
All right, Mr. Loganbill, so let me just confirm that you have an absolute right today to make a statement to me prior to sentencing. Is it your choice to allow your counsel to speak for you today? All right, and Mr. Cornwell, are there others here that wish to speak on behalf of Mr. Loganbill?
I do not believe so,
Right.
Your Honor.
Then go ahead, Mr. Cornwell.
Thanks, Judge. I didn't look, but I listened to these four folks that came forward. Gentleman who talked about his daughter, he was eloquent. And what he indicated was that this is a broken man. And I don't think there's any question about that. Who I will always refer to as Detective Leaper, because I've known her a long, long time. Had I known, didn't know, I didn't mean had I known, would I have not taken the case? No. But I didn't know she was involved in this case, just found out. She gave me the appropriate paperwork. And when comments are made that arguments are laughable, I'm going to stand up and I'm going to say something about that. I'm doing my job. I don't think this is a crime. I may be wrong. Probably will be. But I had a ferocious prosecutor in this case who, good God Almighty, whatever money this county paid her, it's not enough. Look, we all do what we're supposed to do. And you distill everything. And if you've got a prosecutor, if you got a defense attorney, if you got a judge to figure out what we do here, then the system works. And I've tried to do my job. I know the court's going to do his. You already know what I think about the prosecutor's job. I can't imagine what these fine folks are going through. Can't. And so as a defense attorney of 44 years, what you do is you really try not to listen. You really try not to let that get to you. But they haven't spent the time that I spent with this man in the confines of my law office. How he has been in counseling solely for the purpose of him not offing himself. All of the times, I can't begin to imagine how many times he has been on video, Zoom, whatever you call it, talking about what he had done and why should he live. Look what has happened. I sure wish we had a CAT scan or some kind of machine judge that could look inside somebody's brain housing group and figure out what's going on. Court's going to do what the court thinks is best. And I'm going to leave it at that.
All right, thank you. We have hard jobs. I first want to thank everyone who has attended today, both in person and remotely. I appreciate the interest and support that has been demonstrated, frankly, for both sides. I appreciate everyone's interest. All right, the crime at the time it was committed by Mr. Loganbill was defined by our legislature as a Class A misdemeanor. Many, if not everyone in the room, now knows that that law has subsequently been amended. I appreciate the fact that one side of the room acknowledges and understands that Mr. Loganbill can only be charged, convicted, and sentenced pursuant to the law that was in effect at the time, not the law as it was subsequently changed. As a result, the controlling statute is KSA 21-6602, which fixes the maximum sentence at 1 year to be served in the county jail. Now, as Ms. Eaton has pointed out, clearly this court has the discretion to order probation rather than a jail sentence. Interestingly, if we were operating under the current statute and Mr. Loganbill had been convicted of the crime as it now exists as a felony, the court would have the option to order a certain amount of jail time followed by a term of probation with numerous and rather onerous requirements for such things as mental health evaluations and treatment, sex offender evaluation and treatment, etc. And I believe one could make a compelling argument that such evaluation and treatment might serve the community better for ensuring this does not happen again. However, because again, as Ms. Eaton has astutely pointed out, because the crime is a misdemeanor, I believe under our applicable statutes, I must either sentence Mr. Loganbill to jail or probation, and a combination of the two is not a legally available option. This brings me to what I believe the appropriate sentence is. This type of offense committed by anyone is reprehensible. In fact, reprehensible probably is not a strong enough term, but perhaps exponentially more so when a crime like this is committed by someone in a position of trust and confidence, like a close family member, a minister, a coach, a scout leader, a teacher. Mr. Loganbill, although there may have been technically one victim in this particular case, your actions victimize multiple young girls and their families, and perhaps even a whole community of families who trust schools and teachers with the safety of their children. You are a stalker for sure, but you are also a thief who stole innocence from these children. As a result, it is my judgment that you receive the maximum sentence available and hereby order you to serve 1 year in the county jail. Mr. Loganbill, I need to inform you that at some future point in time, you may be able to have this conviction expunged pursuant to Kansas law, and notice of appeal of any adverse ruling of this court must be filed within 14 days of today's date. I'm not going to have Mr. Loganbill taken into custody today. Mr. Cornwell, are you anticipating some sort of an appeal, bond, and motion?
If the court could give me just a second.
Certainly.
We're gonna find out. Okay. Judge, I appreciate you saying that. The notice of appeal will be filed, and normally we have to wait until the journal entry is filed, which then makes the motion for appeal bond premature. That said, I would ask the court to consider keeping him on the same bond that he is on. He has done well. There have been no infractions. He has continued in his counseling. He's done whatever he was ordered to do by the court. So I'd ask the court to consider just leaving him on the bond.
I will, but only for a certain amount of time pending. So what should we set next and when, Mr. Cornwell? I assume that Ms. Eaton will have the journal entry on to you probably by tomorrow or the next day.
That's correct.
Here's my thought, Judge. If you were to tentatively set an appeal bond, then I can go over with that with my client. We can go from there at the court, because you sentenced him to a year, and he's going to go in right now. So the tentative wants to listen to the prosecutor first, then I'll have full range of options for my client. We'll figure out what I need to do next.
Ms. Eaton?
Procedurally, I think we're a little bit ahead of ourselves. So I would ask that you not issue an appeal bond at this juncture.
And I'm not asking you to do that.
All right.
I'm just asking for, if I were to give one, this is what it would be. And so that's my argument. If she wants to make an argument, it should be $1 million or 500, whatever.
Let's do this then. I will have Mr. Loganbill taken into custody today. Can we schedule something perhaps for Monday or Tuesday? I know that I'm going to be out late next week, and then we start a jury trial.
I'm available.
Mr.
We're going to do that by Zoom, Judge?
Yes.
Great. Let me just...
Now, I've said that, but the boss over here may have another opinion about how much time I have. Carl, what's your availability?
I am good.
Tuesday. I'm seeing Tuesday.
Tuesday, anytime after 10:30, although I think I'm going to continue that one. That's perfect.
Tell me that, so that's, Ms. Eaton?
I'm available.
All right, fair enough then. All right, so Mr. Loganbill, you'll go into custody today. We'll set a bond hearing for 1 o'clock on November 9th. Ms. Eaton, anything further?
Nothing further by the state.
Mr. Cornwell, anything further?
Oh, thank you very much, Your Honor.
All right, thank you.
Anything valuable on you? Good command. You got anything on your neck?